you can be charged with a crime in New York if you drive a vehicle while knowing that you have a suspended license. Depending on the particulars of your case, you could be charged with a misdemeanor or a felony. Further, the ultimate outcome of your case will typically depend on your criminal history or lack thereof. For many cases, an experienced New York City unlicensed driving lawyer can help you get a good outcome. If you're arrested for operating a motor vehicle while having reason to know that your license was revoked or suspended, you'll be charged with a crime of Vehicle and Traffic Law 511, aggravated unlicensed operation of a motor vehicle, either in the third, second, or first degree. Aggravated unlicensed operation of a motor vehicle is most commonly charged in the third degree, and that's otherwise known as Vehicle and Traffic Law, or VTL for short, 511, subsection 1, subsection A. A typical aggravated unlicensed operation of a motor vehicle case happens as follows. You're driving down the street and a police officer pulls you over for a moving violation, like a speeding ticket or let's say you ran through a red light. The officer writes you a ticket, and let's say you put it in your glove box. You plan to pay for the ticket, but life gets in the way, and you forget about it. Fast forward a year or so, and you get pulled over again for speeding or a red light again, or whatever it may be. But this time the officer arrests you because your license had been suspended by the DMV for not paying the moving violation ticket. A critical question in all aggravated unlicensed operation of a motor vehicle cases is whether you had reason to know that your license was suspended. Typically, when you don't pay for a moving violation ticket, after several months the DMV will suspend your license for failing to pay the ticket. When the DMV suspends your license, they send written notification to the address that you have on file with them. The DMV also keeps business records that they call a proof of mailing. When the DMV sends notification that a person's license has been suspended, they keep these what they call proof of mailing records that prove that the notification was sent to the recipient's address on file. If the DMV suspends your license and sends you notification to your address on file, then you're deemed as having reason to know that your license was suspended. Accordingly, you can be arrested for aggravated unlicensed operation of a motor vehicle even if you didn't actually know that your license was suspended. All the government must prove is that you had reason to know that your license was suspended, and a proof of mailing is sufficient proof. It's not uncommon for a person to change addresses and forget to tell the DMV. Such a person would not necessarily receive DMV correspondence that notifies them that their license is suspended. However, they could still be criminally liable if a notice of suspension is sent to their old address and they operate their motor vehicle with a suspended license. An experienced New York City unlicensed driving attorney can assess whether you might have a defense regarding the proof of mailing or some other aspect of the case where there might be a winning defense. Aggravated unlicensed operation of a motor vehicle in the third degree is a Class B misdemeanor. If you're convicted, you would get a criminal record and you could be sentenced to up to 30 days in jail, plus a fine of up to $500. If you commit aggravated unlicensed operation of a motor vehicle in the third degree and certain other factors exist, your charge will be bumped up to the second degree, which results in worse penalties, including up to 180 days in jail, as well as higher fines. The aggravated factors that will bump your charge to the second degree include you've been convicted of aggravated unlicensed operation of a motor vehicle within the last 18 months, or your license was suspended due to driving while intoxicated related issues. Also, an aggravating factor would be if you have at least 3 suspensions on 3 separate dates. If you commit aggravated unlicensed operation of a motor vehicle in the second degree and other aggravating factors exist, you will be charged with aggravated unlicensed operation of a motor vehicle in the first degree. This charge is a Class E felony, and if convicted, you could face up to 4 years in prison, as well as fines of up to $5,000. The aggravating factors that can bump a charge up to the first degree include you are illegally operating the motor vehicle by virtue of being impaired or intoxicated by drugs or alcohol. Also, if you have 10 or more suspensions from 10 different days. Another factor could be if your license has been permanently revoked when you're driving. So not suspended, but completely revoked and it's permanent. If you are charged with some degree of aggravated unlicensed operation of a motor vehicle, the outcome of your case will depend on which degree you were charged with, as well as the particulars of your case. For most people charged with unlicensed operation of a motor vehicle in the third degree, the most common degree of the charge, a New York City unlicensed driving lawyer can very likely get your charge reduced to a non-criminal traffic infraction, a Vehicle and Traffic Law 509, if you have never been previously charged for driving with a suspended license. Also, a skilled unlicensed driving lawyer could possibly convince the prosecution to completely dismiss the charges in the event that you're willing to pay the DMV for any fees owed in order to get your license restored. Either way, if you have been charged with aggravated unlicensed operation of a motor vehicle, even if you're guilty, you and your lawyer can explore options to get a favorable outcome. If you've been charged for driving with a suspended license, give me a call for a free consultation. I'm an experienced unlicensed driving attorney who can assess your case to determine the best path forward.